therefore, is the branch of international law. Why do we call it a branch of international law? It is a branch of international law because it involves people from different states. But the distinction between private international law and public international law is that the subjects are not states in this instance, but individuals. So, meaning even the nature of laws that are dealt with under private international law, these are private branches of law. I assume that at this level, you know the difference between private law and public law. So, therefore, private international law or conflict of laws is a branch of law that regulates relations between parties involved in cases with a foreign element. That is the definition of private international law. It involves cases with a foreign element. What do I mean when I say cases with a foreign element? It simply means that we can have a Zambian national, a Namibian national, a Congolese national who go to South Africa, maybe establish a company and employ some South Africans there. And they enter into maybe a series of contracts. Now, when a dispute arises, the first question that we're going to ask ourselves is that which law are we going to rely on? Because we have nationals from Zambia, from Congo, from Namibia, and from South Africa itself. To make matters worse, maybe they even contracted someone from Australia. So you can see that this transaction is moving across borders. It is moving across continents, and a dispute arises. Now, one of the major functions of law is to adjudicate upon disputes, but it matters which law you are going to apply when adjudicating upon those disputes. So this is the function that conflict of laws performs in our world today, to bring about a solution in complicated disputes which may have different parties from different nationalities, perhaps who entered into a number of different and separate agreements, which somewhat can be confusing up to a certain extent. But at the end of it all, no matter the circumstances, a judgment is supposed to be passed, and above all, justice must prevail. So that is basically what conflict of law is about. So I've tried to simplify it to you, the nature of actions that you will find in conflict of laws. And conflict covers many areas, or rather branches of law, such as contract. Conflict will cover many areas, such as family law. Conflict will also cover issues such as tort, because like I have told you, conflict is involved more with private agreements that individuals enter into, and particularly where these individuals are coming from more than one state. Because if you're both coming from Zambia, it shouldn't be an issue. But where you're coming from different nations across the world, then it becomes something to talk about. Any questions so far? Any questions?
No.
By the way, just a minute. Are you also taking intellectual property? Are you
No.
taking intellectual property?
No.
It's not this class? Okay. Yes, please. You can go ahead. Any questions?
I think no question.
Is it very clear? Has everyone understood? Hello, are we together? I can see about 18 participants, but only one voice is being heard. Are we safe? Or have you just logged in? You've gone back to sleep. Where is the rest of
No,
the class?
we're here.
So I want to get your response, because if only one person is answering, I wouldn't know. Maybe some of you have been cut off. Where aren't you clear? Because this is the most important part of conflict. If you will not understand this first part, then it will be difficult for you to understand the subsequent topics. So I want us to move on the same page.
It's clear for me, madam.
All right, thank you so much then. Now let me just talk about the importance of conflict, or maybe I can say the functions of conflict of laws. What is its relevance? One of the reasons that I can give as being the importance of conflict is dispute resolution. And like I have explained, that conflict cases are very confusing. Even when you be reading the cases, you will discover that they are very confusing for you to just grasp the principles and come up with a roadmap as to how they're going to be resolved. So dispute resolution is one of the key functions of conflict of laws. Secondly, conflict of laws promotes what is known as a comity. I'll be able to explain that later. When we talk about comity, it simply means that we as members of the international community are able to acknowledge and also respect the legal systems of other countries. How? If a Zambian has entered into a transaction with people from other nations, applying the rules of conflict, it is settled that this case is most suitably to be heard in a South African court. So for the Zambian court to be able to allow their citizen to go and participate in an issue which is in South Africa, it means that we are acknowledging and recognizing that South Africa also has a legal system which is competent enough to make decisions just like here in Zambia. So that act of recognition and respect for other legal systems is actually developed by conflict of laws, because cooperation is actually one of the key aspects of conflict through which decisions can be made. Without cooperation between the courts, then a case cannot be concluded. So you discover that committee, I would say cooperation is enhanced, and also it leads to development as you are interacting with each other, as nations are interacting with each other, trying to resolve disputes. You find that that is how we get to learn so many things. That is how we get to exchange so many skills. That is how we get to improve and adapt to the changing realities of society. I can give an example of COVID, which has just come in. So legal systems in a way have also been affected by COVID, because are you aware that right now some court sessions are actually being held online in some jurisdictions? For example, we may have a judge who is maybe, let's say, in Zimbabwe, but sits maybe on the Court of Appeal of another country. So in the event that they're not able to travel out of that country, they're actually hearing from their own domestic countries, but on the other hand, they are hearing cases from other countries. This is a development that we're talking about, and it only comes about when courts are working together. So that is development. You can have an introduction of IT into the system of dispute resolution, like we're experiencing right now. And the other one is that it does promote justice as well, because when trying to settle for what are known as choice of law rules, the most important thing is that the jurisdiction which will be settled for, to say this is the most appropriate forum to handle a case in conflict, will be always the jurisdiction which is achieving justice best in the case. So in that case, we'll say that it promotes justice. So you can come across several other functions of conflict, a very, very important branch of international law, being private international law in this respect, because we are all used to public international law. So, any questions? I would like someone to give me their email address so that I can share the notes. I want to quickly share the notes.
Ma'am, I'm sending you my email address on the group.
All right, just give me a few minutes so that you share the notes. I'll give you time to share the notes, then we'll get back.
All right.
Can I have another email address so that I can send to two? Right here on Google. Google Meet, just post it. Yeah.
I think Amanda has posted her email address.
I want another one in case it bounces. Okay. Have you received the notes? I've sent to 3 people. Have you received the notes?
I haven't received yet.
I've sent to Tamanda, Lakson, and Joseph. 3.
Okay.
Yes,
Amazing.
just quickly check your email.
I've received them.
Okay, can you share them with the rest of the class?
Okay,
Because when
sure. I'll do
teaching,
that.
I need to refer to quite a number of cases so that you understand.
Okay, let me do
So
that to
let me
share.
give you some time to share with the class.
Okay.
I don't know how you do it.
I'll send them on WhatsApp.
Yes, do so.
I have sent to the group.
All right. I want us to go to the module. Open the module. Open the module. I don't know. Have you all been able to access the module? All right. I want to talk about the basis of conflict of laws. I want to explain the basis of conflict of laws. So when we talk about the basis of conflict of laws, basically there are three main reasons that we look at. And the first one is justice. So the most important thing that a court has to consider in a case involving a foreign element is whether that particular case is going to achieve justice or not. So before they settle for a certain jurisdiction, you say maybe country A or country B is the most appropriate forum to deal with the matter. The courts have to bear in mind whether that country is the best forum that is going to achieve justice in the case. So justice is at the core of conflict of laws. It must be considered at all times before a particular issue is transferred to a certain jurisdiction. Can you mute your mics? I'm getting bad feedback. Mute your mics. There's someone who hasn't muted their mic. Please mute your mics. All right. Apart from justice, we have comity. I explained to you to say comity, this is where you acknowledge the existence and competence of other legal systems. So if a need arises, your own national can be a party to the case, but you need to be able to surrender them to another jurisdiction if that is the best thing to do. So that is comity. This is also closely linked to reciprocity, to be able to reciprocate. So that is comity. And we also have public policy. When we talk about public policy, this is where we hold certain views in common as states around the world. Is it satisfying the public morality? Is it something that is acceptable by all states? That is public policy. So these three are what are known as the basis of conflict of laws. So whatever decision has to be made in conflict of laws, it must reflect the three core principles of conflicts, which are justice, and then we have comity, and then public policy. Are you able to see what I'm projecting? Are you able to see what I'm projecting?
Yes, ma'am.
Yes.
Any questions before we proceed? Anyone with a question? So everything is very clear. Would I
Yes,
be right to
so
assume
fine.
that? Crystal clear. Wow, wow. What a brilliant class. Okay. Now I'm about to explain something very important. When there's an issue in conflict of laws, there's a certain sequence of issues that you're supposed to consider. But I think before I go to that, let me just give you a few minutes break because I'm about to connect to something slightly different from what we've been talking about. So can we break off for 10 minutes? I'll be back. Let's have a breather before I introduce something new. All right?
Okay.
Okay.
So do we leave the class?
Okay. I think the break is over. You've rested a bit. So, well, I want us to come to a part that actually gives us a guide as to which factors we need to take into account in order to arrive on a particular jurisdiction as the most appropriate forum to handle a case. So when you have a case, just like any other case, the most important thing that you need to look at are the facts surrounding that particular case. And in conflict, we call that characterization. So we look at issues of characterization. And when we talk about characterization helps us to understand the nature of the issue. It will help us to understand whether it is a contractual matter, whether it is a family law matter, maybe whether it is a tortus matter. That is known as classification or characterization. So once we are able to know the actual issues surrounding a particular cause of action under what is known as classification or characterization. So meaning we can settle to say, okay, this is a contractual issue. That is step one. Once we know the nature of the issue, the second question that we're supposed to ask ourselves is, what is the position of conflict of laws in relation to this issue? Now, when I talk about issues of the position of conflict rules in relation to the issues, it will bring us to what are known as connecting factors. A connecting factor is simply a link of an event, a dispute, or a person to a particular legal system. That is a connecting factor. So this is a link between the issue at hand to a particular legal system. That is known as a connecting factor. So a connecting factor is the one which gives us direction that we are going to take in a particular issue. Now, what you need to know is that after we identify the issue under characterization, whether it is tort, whether it is a contract, whether it is a family law issue, the connecting factor will now give us the position as to the general rule which is supposed to be applied. And remember that this whole process that we are talking about may fall under a broad umbrella where we say choice of law rules. When we say choice of law, we are simply trying to settle for the most appropriate laws to be applied. But before we come up with the most appropriate laws to be applied, these are things that we consider. Characterization or classification, we look at the connecting factors because we are trying to sieve through the facts of the case whereby in the end we're going to settle for one jurisdiction to say, okay, we're going to use Zambia as the most appropriate forum to settle the dispute between the parties. Now connecting factors are in Latin. So what you need to do is, these are the connecting factors. These are the connecting factors. So for example, when we have lex causa, the law which governs an issue, possibly this is under contract. lex actus, the law governing a transaction, such as the applicable law of a contract. Lex domicili, the law of a person's domicile. Lex fori, the law administered by the court hearing a case. This is the local law. When we say lex fori, this is the domestic law. If we say lex fori of Zambia, we're talking about the domestic law of Zambia. Lex loci actus, the place where the transaction is concluded. Lex loci delicti commissi, the law of the place where a tort is committed. Lex loci solutionis, the law of the performance of a contract. Lex situs, the law of the place where property is situated. So the way these connecting factors are, when you are given a case, you are going to pick on the most appropriate connecting factor dependent on the nature of the characterization of the issue. If it is, let's say, a contract, you will go for the connecting factors that are connected to contracts. If it is a marriage, it's just that Alex loci celebration is maybe is not captured here. If it is a marriage, we go for lex loci celebrationis, the place where the marriage is celebrated. Then you will start from there until eventually all the facts will unfold and you settle for one legal system as having maybe the most appropriate reasons to settle the matter. Any questions before I proceed? Just up to there. Any questions? Are there any questions? I know conflict is confusing, so you cannot tell me that everything is clear up to this point. No. I think some of you are lost. So please ask where you're not clear. At this point, you start getting confused. So where you are not clear, please, you ask, because if you miss out this part of the lesson, which means the entire course will confuse you if you miss what I'm teaching today.
Madam,
Yes, please.
on lex actus, is it
Yes,
possible
please.
for you to give us perhaps a scenario example?
Lex actus, the place where the act takes place. It's just a
Lex,
contract.
well, I was a bit confused where it stated that the law governing a transaction, such as the applicable law of a contract. So it's basically the contract itself.
It is a contract. I'm sure you know that a contract is concluded according to the agreement of the parties. So if the parties agree, maybe let's say there's a foreign jurisdiction clause, and you say that the law which will be applicable to our transaction is Australian law.
Okay.
So that is the law applicable to the transaction. Sometimes it can be the law of the place where the contract is concluded. Sometimes it can be the law of the place where the contract is to be executed. Those are the options under contracts.
Okay, thank you.
Yes. Any other questions? Do you have any other questions? Any other questions? I'm talking about the roadmap that we follow in trying to settle for a certain jurisdiction. I've said first you look at classification or characterization. Then you look at the connecting factors. Now, there's something also which is very important that might arise So there's something important that might arise. A number of questions might arise in the process. Let's say you want to determine the validity of the marriage. For example, if it is a family law issue, so maybe they are questioning something to do with, let's say, inheritance. Now, before you can conclude in conflict of laws to say maybe this child B, can inherit the property of the parents, there are certain questions which we need to ask ourselves. First of all, we'll ask ourselves, is this child a legitimate child of this couple? If yes, was the marriage valid? If yes, maybe were the proper formalities of the marriage followed, and so on. So as we are asking ourselves these questions, which will help us to conclude whether this child is entitled to inherit the property, what you need to know is that these questions are known as incidental questions. Incidental questions are very important in conflict of laws in a bid to try and determine the choice of law rules, because in the process, depending on where this marriage was conducted, we'll make reference to that legal system, depending on where the property is situated. And the question is it movable or immovable property? So different connecting factors, again, as you are raising these incidental questions, will also come about. So this is how conflict issues are normally looked at. So when you look at classification and characterization, find the appropriate connecting factor. When you find the appropriate connecting factor, for example, like I told you, we're looking at issues of family law. Under that, there will be a number of issues also connected there. So now, as we begin to ask ourselves questions to ensure that the matter is taking a definite and clear direction, we need to ask what are known as incidental questions to address the issue comprehensively. And at the end of it all, as we're addressing these issues, what comes up is a very important issue of what is known as jurisdiction. Jurisdiction now is what is used finally to settle for one particular legal system. I'll be able to explain this in more details. You'll be able to understand, especially when we look at one or two cases. So what I have done is just to give you a general overview of some of the things that we look at when we're trying to come up with a proper law doctrine in conflict of laws. Any questions? Are there any questions? Are there any questions? All right. If there are no questions, I'll end this session. I'm going to post something from my previous classes, some discussions that I was having with them. Just follow those notes through. I'll give you some time to read through, maybe 1 hour. Then I'll come back to receive questions. But I think that will be done via WhatsApp because I'm ending this Google Meet session. Then let us communicate.
All right.
What is that now?
All right, thank you.
Okay, so let's meet in the